Right, the court has reviewed the documents. Is there anything your client wishes to say?
No.
So if you all can, I understand what the witness stated, but if y'all can explain to me how he commits one aggravated robbery, pulls a weapon on somebody. Then in the report, he says he's only doing it. And this is from the stipulations. He's saying he's only doing it because somebody forced him to do it, some man he doesn't know. And that he was at Sam Houston High School attending. But my understanding from testimony is that he was homeschooled. And I guess at some point he went to Sam Houston.
Yes, Your Honor. So he transitioned schools because he was finding himself in a position with these kids that he was trying to escape.
All right.
And
So-
so that was part of the reason why he transferred schools to a different location to try to get away from the environment that he was experiencing.
All right. So if somebody can explain to me how he commits one aggravated robbery, and then the next month he commits another and he doesn't internalize that this is the wrong thing to do.
I think the main thing, Your Honor, that was affecting Alex at this time was his environment and this external pressure, threats, and the people he was around at that time. And with him being so young and trying to understand exactly what is the right decision, how do
How old were
I,
the other people who were with him?
they were around the same age, Your Honor. And it's those situations where, you have a group of young kids, Alex, who wasn't the one, holding the gun to the store clerk, but knows, I'm in this tough position. I'm being threatened. At the same time, I know this is wrong. And I want to be clear, Alex from day one has taken accountability for everything.
Right. So if he's saying that he's being threatened, unless the law has changed, maybe it has, I don't, say that I know everything, but if he's committing an offense under duress, then isn't that a defense?
It is, Your Honor. And we talk about these things with clients on how they wish to proceed. And
So he doesn't want a jury trial?
at this time, no, Your Honor.
Okay.
Mr. Avila has been through more than most people since his young life. And there are times when, as a kid, he's trying to make the good decisions with the influence of his parents, moving to a new country, trying to get the health care for his brother. And as we stated to the court, he takes accountability for everything, and he knows exactly where he went wrong. And I think one of the things that spoke the most to me was when I was sitting with Mr. Avila and we were talking about letters from people and family, and he's the one himself that said, I wanted to write something to Judge. And we sat several times where we passed revisions. He's like, I want to make it as grammatically correct as possible. What else? What can I talk about? And that exchange really spoke to, I think, the core of who he was and who he is. He's recognized where things have gone wrong, and he's recognized where things can go even worse for him in his life. And I think that's a lesson that a lot of people who come before the court learn at different times. And so for me to see that growth in him at such a young age when speaking with him, I think is what spoke the most to both the social worker and myself. Mr. Avila is someone who was caught in the wrong place, wrong time, wrong factors. But he is also someone who takes accountability. He's also someone who is trying to carve out steps for himself and create a plan of success. And to see that for someone his age, I think is pretty remarkable. I told him the options, and we've discussed what could happen. And, he's asking the court for probation, and he would like the chance to tell you and show you exactly what he is capable of and how he can turn his life around. And I wholeheartedly think that that chance should be extended to him. Let him prove to you. And if not, the alternative as well. But at least give him this chance to show you exactly what he has learned, what he wants to do, and how he wants to move forward with his life, not only to correct the harm that he's caused, but also to become a productive member.
All right, state.
Judge, regarding this offense and the letters that I reviewed during the time of his incarceration, yes, the defendant has come to learn that what he did was wrong, but I mean, he knew it back then. And in his letter that he wrote, he's falling on the sword because he knows that he's coming before this honorable court. I think that in reviewing the stipulations, I think that he's displaying a continued pattern of, with the use of other people's SID numbers, that is against the rules that are in jail. So a pattern of continuing criminal behavior. And then also, I mean, this was not just one aggravated robbery. It was, they hit one store and then are, collecting and appropriating property from that store. And then they go back. And these are people that he met at school, I might add, and then they go to another store and then a third store. And so while I understand what counsel is saying, I mean, this was a continued pattern of criminal behavior, violent criminal behavior, where he states that he was aware that these robberies were going to occur and still chose to engage in this criminal conduct, Your Honor.
All right. So here's the thing, and I want you to understand my thought pattern and why I'm doing what I'm doing. I talk to children all the time, and you know what I always tell them? If you're with a group of friends and you all are planning a robbery, you might as well go in the store yourself with a gun, because if somebody else went in the store with a gun, it's like you went in the store with a gun. That's the way Texas law operates. And my problem with you is I understand you're young, and that's what I'm trying to balance. I'm balancing the fact that you're young. I'm balancing the fact that you didn't have a gun, because I've had clients before where they're just the lookout. Somebody gets killed, they're charged with murder, they're looking at life in prison. But you were more than just a lookout. You're opening doors for people. And part of the reason why everybody is charged the same is because historically, if you look at the way the law was written, they're thinking that maybe this crime would not have happened but for your participation. Sometimes if somebody says, well, I'll be the driver to this robbery, well, maybe if that person would have said, no, I'm not driving anybody, then everybody would have said, well, we can't do this, we're not going to do it. But you continued, and it's not just one. So the state is asking for a cap of 10. I'm balancing your age. Hopefully you have learned something. And I'm also balancing the fact that you did not have a weapon, but at the same time, I'm balancing the fact that after everything happened, you all sat around and counted money. Do you even remember what happened to your share of the money, what you used it on?
None of us know.
I didn't spend it.
Sometimes people go to a convenience store, they end up killing the clerk, and you know what? They end up with $20. Was that clerk's life worth more than $20? Most definitely. Is time going to prison worth more than the $20 you had? So I'm going to find you guilty. Does anybody want to speak to the cap?
Your Honor, we would ask for the lowest possible. We know that the court is taking into consideration everything that is happening. Just so Mr. Avila can get what he has planned, done, and he doesn't waste time in the beginning moving and potentially experiencing more negative things that would harm and actually impact him coming back to the system. We understand the court's position, and we understand the things the court's taking into consideration. And I think this is one of the opportunities where the law allows for just this, where you get to exercise your discretion.
But I am asking for the time. I did review everything that was prosecuted and over testimony with the witness, which was provided to me, and that was factored into the plea bargain. And I think another aggravating factor is that there were other people that were with this defendant and this co-defendant that were unidentified. And so, we would ask for 10 years.
All right, the court is gonna find you guilty in each cause number. The court will sentence you to a $2,000 fine. Time and money to run concurrent. Court will give you credit for any time served. The cases will run concurrently. Court will take in consideration 2025 CR 001801A, 2024 CC 741988. There's an affirmative finding of deadly weapon. The court will request the therapeutic community. Court will sentence you to 7 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes,
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
yes,
All right, we can go off the record. Here's the thing. I understand that prison life is extremely hard. If I had all of the money in the world and could build a prison the way it should be built, every inmate would have their own cell. That wouldn't be 4 to a cell, 5 to a cell, or any of this. But I understand that there are bad things that happen at the prison. But here's the thing. Do not waste your time at the prison. There's some free education there. Make sure you do that. If they have a welding program, get in a welding program, and do not become institutionalized. And do not get tattoos all over your body, because people will recognize those as prison tattoos. When you're released from the prison, if you have any problem finding a place for any alcohol issues you have, any mental health issues you have, if I'm still here, you come back here, I'll pick up the phone and find transitional housing for you. All right, good luck to you.
Very happy.
All right, so do you have the same records?
Yes, Your Honor.
And state, have you been able to tender an offer?
We're just comparing, I do believe defense counsel is letting me know that she has reviewed the CPS records that we had already tendered, and there seems to be something that they believe is missing, so.
What is missing?
Some information about another allegation that occurred between one of the CWs and a different juvenile. We saw the body cams and the CW's mom discusses that, so we didn't see anything in the CPS records about that, although she did state that CPS was called. So we do want to confirm that if CPS was called in regard to that allegation or not, because it would have been, it was important to his defense.
All right, Ms. Ferguson, reset this in 3 weeks and state you'll need to be prepared to tender an offer.
Yes.
Thank you, Judge.
Sure. What date?
November 5th.
November what?
10th.
All right, so you're gonna be back on November 10th. All right, thank you.
Thank you, Judge.
You're welcome. All right, next.
I have Edward Lopez, on page 3, third one down. They're also on the 3795.
Edward Lopez.
Well, Your Honor,
Good morning.
may I approach Judge?
Yes.
Judge, in this case, Mr. Valdez, we found the PTV agreement. He's remanded without.
No,
bond.
Edward Lopez.
Yeah, I'm sorry.
That's okay. Where's the attorney?
It's 379.
All right, just give me a moment. Give me the next one. Just have a seat, sir. We'll come with you shortly.
Next I have. Page 8, second down, Edward Valdez.
I'm sorry, which page?
Page 8, second down, Edward Valdez.
All right, Edward Valdez.
No, right?
Yeah.
Okay, but Judge, in this case, Mr. Valdez is remanded without bond. He and I went over the PTD agreement.
Mhm.
He signed it. However, he's wrong without bond. So this is a court's copy. I made a copy for you, Judge. And we asked them to grant him a PR bond so he can be released.
So
and-
why is he remanded without bond? Is it for, he's a no-show? That's what it says in the system. So he is not eligible for a PR bond.
Okay, so then how is he supposed to start the PTD program?
Oh, you'll need to file a motion. I'll hear it and bond will be set.
Okay,
All right, thank you.
okay, thank you, Judge.
You're welcome. All right, who's next?
Next I have. Page 1, fifth one down, Stacy Smith.
Stacy Smith? Stacy Smith? All right, next.
Page, oh, I'm sorry, that one is this one, I apologize. Trying to keep them in all.
All right, 30-day reset on Smith. Who's next?
Page 7. Second and third one. For Lennon Cortez.
Lennon Cortez? All right, where are we on discovery?
I still need to get discovery. I had an issue come up here, with Mr. Cortez.
Okay.
Verbal interactions and, I'm not going to be intimidated. So I'm asking for a motion to withdraw in this case. I don't feel that I can communicate with him. I hate to do this, but, it's one of those situations. I don't need to be stared down. I don't need the intimidation. Maybe another attorney he can do better with.
Okay,
Try to give him his options. And he doesn't want to listen.
all right, thank you. You're excused.
Thank you, Judge.
You're gonna get one more attorney. That's it. After that, you can represent yourself or you can retain one. Do you understand? Everyone needs to be treated with respect. I don't know why you think being disrespectful for your attorney will make your attorney want to represent you better. So just have a seat. An attorney will be appointed to you. Court is calling 2025 CR 012124 State versus Stephen Daniel Flores Jr. Can I have parties announced?
In Galley for Steve.
Andrew Frelick for Mr. Flores.
And are you Mr. Flores?
Yes, Your Honor.
All right, you'll need to speak up so the court reporter can hear.
Yes, Your Honor. Judge, he's having trouble hearing out of his left ear, so if we could, I'm gonna try to speak as loud as I can for him as well.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Flores, did you review the true bill of indictment with your attorney? Did you understand it?
Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
That's you. Thank you. You
Yes, Your
proceed.
No problem.
Yes, we're proceeding.
Mr. Flores, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with evading arrest detention with a previous conviction as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Flores, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, Your Honor.
Has anyone promised you anything other than the plea?
Oh, Your Honor.
Are you satisfied with the way you've been represented?
No.
You're not a U.S. citizen. By entering into this plea, you may be deported, denied naturalization, or re-entry into the States. Did you understand?
No.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 9 months in the state jail facility. There's a $2,000 fine, no applications. The state will take in consideration 2025 PF 28226, 2025 CR 012123. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
No.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
No.
Counsel, have there been any such motions?
Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Answers.
State any evidence.
The upper states mark the attachment.
No. No objections.
State you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in both, in all appropriate places?
No.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
No.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. Wait, PSI.
Anything you wish to say on behalf of your client?
Here, we ask you to follow the plea bargain agreement.
All right, the court will sentence you to 9 months in the state jail facility, give you credit for any time served. There's a $2,000 fine, time and money to run concurrently. Court will take in consideration 2025 PF 28226, 2025 CR 012123. There's to be no contact with 6814 Military Drive. That is the Quick Trip store, and the court will recommend the Therapeutic Community.
Thank you, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
No.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing, the therapeutic community is to help you with any drug or alcohol problem you may have. I cannot force them to place you in that program. I don't have the jurisdiction to do that. But they'll see on the judgment that I'm requesting it. You'll have to request it as well. If you do not take care of your drug or alcohol problem, you know what's going to end up happening? You're going to be living your life at somebody's prison, somebody's jail, or either somebody's going to be identifying your body. You understand? When you're released from custody, if you can't find a sober living house, if I'm still here, come back here and I'll find a place for you. All right, good luck to you, okay?
Thank you.
You're welcome. All right, so there was going to be PTD and then what, not PTD?
Yes, Your Honor, PTD, we just submitted the application today to the records department.
All right. So Ms. Ferguson, I need a date for PTD. All right. And so the application has been submitted.
Yes, Your Honor.
All right, we'll bring you back on 11:20. Make sure you follow through on everything that they're asking of you. Do you understand?
Your Honor,
Yes.
is there a possibility that I could get it the week prior or earlier that week? I'm gonna be out on vacation on the 20th.
What I can tell you is usually that's the length of time it takes for completion of everything. If everything is completed, then they will have sent me the proper documents for me to sign, and it'll probably be done. So if it hasn't been done, she's just gonna get another reset.
Understood, Your Honor.
Right. So we'll see you back on November 20th. Just make sure you follow through on everything, all right? All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused. Thank you.
Thank you, Judge.
Thank you,
Have a great
counsel.
day.
You too. All right, who's next?
I have,
Are you all ready?
We're on the list, Judge.
Okay,
Also, there are a couple, we've submitted a memo in that case as well, so when it comes to us, there is a sentencing memo.
all right. Can I see the sentencing memo?
for Lunsford?
I don't know. What's your client's name? Lunsford? Is that next? And defense, are you all going to have witnesses? Okay. And state, are you going to have witnesses? All right, so if parties can approach on this case, please. So has the restitution been paid in full? All right. And before we go on the record, any objection to the court reviewing the PSI?
No, ma'am, no objection. The only qualification is there is a letter written by a ex-mother-in-law that really has nothing to do with the merits of the case.
Is that Matthews?
Yes. Yes, ma'am.
Okay. So you'll object to the court reading that?
I don't object to you reading it. I just simply asked that it be taken into and put in the context it deserves. As I told Mr. Locke, without diminishing the seriousness of today at all, if I'm ever sentenced and any ex-mother-in-law I have has a vote, I'm going to the Polonsky unit. But other than that,
Really?
yes, ma'am.
Oh,
2 out of 3 anyway.
okay. 2 out of 3. Is there a common denominator?
Yes,
in all
ma'am.
those?
I'm looking at it. Yes, ma'am.
All right, just y'all can remain here. Just give me
Sure.
5 minutes. Righty. We're gonna go on the record. Court is calling 2025 CR 001023, State versus Mark Davis Lunsford. But I have parties announced for the record.
Dan Togdell and Sam Locke for Mr. Lunsford, Your Honor.
And are you Mr. Lunsford?
Yes, Your Honor.
You entered a plea in this case. As a part of your plea bargain agreement, you will to pay the restitution upfront. The restitution amount was $297,000, well, approximately $297,000. Has that been paid upfront?
Yes, Your Honor.
According to your plea bargain agreement, the state is opposed to your application for deferred adjudication. The state is recommending community supervision. What I can tell parties, since he has paid the restitution upfront, the court is going to follow your agreement in the granting of community supervision. So the only thing that needs to be addressed here is the application for deferred adjudication. And state you are opposed.
Yes, Your Honor.
All right, and if you could explain.
Yes, Your Honor. There are 55 counts in this indictment. This defendant pled to one of them that encompassed much of the conduct. But at its essence, it's just a theft case. It's a theft case. It's a theft that went on for many years. What we allege is from at least 2010 to 2019. Mr. Lunsford was an insurance agent. He stole money from his clients. And it went on for a long time. It went on repeatedly. And it went on even after the Department of Insurance revoked his license practice and to sell and collect payments and that sort of thing. I know the court hears a lot of theft cases, and it's certainly a miserable experience to be victims of that. But I think it's even worse whenever it involves a breach of trust that results in victims losing a sense of security. We all rely on certain people to handle our money, and we trust them to do that, whether they be financial advisors, bankers, insurance agents, etc., CPAs. But I think we have that luxury of trusting them to handle things the way we want to be done. But these victims in this case will probably no longer have that luxury ever to have that sort of things. And the plea bargain reflects that Mr. Lunsford has been remorseful, has made upfront restitution of these victims as what we can collect. And I think that the reason that we are opposed to the deferred adjudication is so that the punishment for Mr. Lunsford will have a permanent effect and will have the effect of warning others in the future by having it on his record. The state did also seek a jail sanction as part of the plea bargain, and we recommended it in the plea bargain because of the scope and gravity of the fraud that was perpetrated by Mr. Lunsford. It's laudable that he made this upfront restitution, and that was a primary goal of the state, so that these victims did not have to be delayed justice any longer in this case. But the reality is that payment could have been made at any point while this case was pending. It was pending for a long time to be indicted, and Mr. Lunsford is aware of the investigation. So for that reason, for justice for these victims, that's why we are asking the things that we are asking for today.
All right.
Good morning.
Vince.
Mr. Lunsford is here today with his wife Claire, with his first cousin George Craig, and Miss Landers and Miss Salinas, who are neighbors of Mr. Craig. He's 49 years old, save and except a fight that he got into when he was 17 years old that was resulted in his successfully completing a misdemeanor deferred. This is his first interface with law enforcement. He has, as the state pointed out, made right at $300,000 in restitution. He is happily married. He has 2 adult children by a prior marriage, 2 stepchildren by this marriage. The difference in deferred adjudication is a difference with a distinction in this case for a number of reasons. One, it's a first-degree felony. If he should violate the terms and conditions, obviously he opens himself up to the full range. Second, he's a certified crane operator. A straight probation, which is obviously a conviction, will bar him from doing work at a federally supervised facility, which basically in Houston is about half his work. So it's going to impede significantly on his work. But we would ask that the court consider the deferred adjudication, given his full restitution, given the community support he has, and given his ability to continue to be a successful employee.
All right. So what I read in the PSI, there's a mention by someone who's not his ex-mother-in-law. Someone else said that he had done this before with State Farm.
I don't believe that's in the evidence that was submitted, State's Exhibit 1. That person may have had knowledge of that information. I generally have knowledge of that, but not specific information enough to give the court about the prior case. And
well, I'm just addressing it because it's included in the packet that I received with the PSI. So does anyone want to address that?
Yes, Judge, just briefly. there was discussion about that specific letter. I believe that's the unsigned letter that purports to be on behalf of 4 people.
Yes.
There are allegations of uncharged conduct that we saw today for the first time. I would submit to the court that the state has had this case for a while. It's been ongoing litigation. If there were other charges to be made, they would have brought them. The plea bargain before the court was with the work of Mr. Stout on behalf of the state and Texas Department of Insurance and counsel for Mr. Lunsford. And we'd ask that the court rule on what's in front of it that's been charged. It's just a vague allegation without a signature, and it's very difficult to address, Your Honor.
All right, so are both parties asking the court to disregard that?
Yes, ma'am.
Yes, sir.
All right, then the court will disregard that.
One brief reply in response to Mr. Stout, Your Honor. He indicated that it took Mr. Lunsford a minute to effectuate restitution. We made it clear from day one when he was charged, I think back in February, that our intent was to pay this. It took Mr. Stout a while to get the restitution effectuated or together, which we understand. But we've always represented, we wanted to make restitution.
All right, so here's my question, and I'm just trying to weigh on whether or not to grant his deferred or not. What was the end game? Because, and by that I mean, because there are a lot of people who are involved. And what the court is seeing is some of this, I think it's listed as elderly persons who had, I guess, their premiums or whatever that they thought they were paying that were taken. I mean, what did he not think anyone would ever report this? Did he not think that at some point somebody was going to need to use their insurance and then their insurance is canceled and they don't know about it? What?
Judge, I can't crawl back in his mind back at the time. I think this was another example of, for lack of a better description, thinking that he could muscle his way through it and eventually get the insurance that these people wanted, and just never did.
All right, is there anything you wish to say?
Just like to.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Mark.
All right, what would you like to say?
I submitted a written statement that just to kind of hear that if I may. Just wanted to.
Oh, have you seen the statement?
Is it the same one that's in?
It's in, yes.
Okay.
Just, offer my sincere remorse to all the victims, to everybody involved in this case. Take full responsibility. It left a mess in my wake. There's decisions.
But I mean, see, I love to have as much information as I can have. I'm trying to figure out, what were you thinking when you were doing this? Because it's more than one person. It's not, oh, I did this one time. Did you need money? I mean, what was the point?
My business was failing. I was trying to cover bills, and it kind of snowballed on me. I knew it was wrong at the time. I felt there was my course of action at that time, and that I would correct it, I would fix it, and it just got out of hand. Doesn't excuse my actions. It was wrong. They're wrong. 2019, I walked away from all that. Fully employed by the then employer ever since.
All right. Is there anything else?
Nothing can say.
All right, I'm going to give you a choice because it appears that you don't have any criminal history other than this. Is that correct?
That's correct. Yeah.
All right. And I've been asked to disregard certain things, and if there's no information before me that the state has, that the defense had a chance to question and put to the test of its truthfulness, then I'm not going to consider it. So these are your choices. This is your only choice. You have no other choice. 1, I'll grant your deferred for 10 years, but you're going to be taken into custody today, and it's going to be 180 days. 2, I can find you guilty, and I'm not going to give you any time as a condition of probation. Those are your only two choices.
Take option 2 now.
So no jail time. All right, the court is going to find you guilty. The court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person, regular random UAs. There's to be no employment handling any financial transactions. There's to be proof of employment within 45 days. No employment as a home healthcare provider or with minors. There's to be 200 hours of community service restitution. Probation, the felony anti-theft course, is that similar to CAT's 1 and 2 theft course, or is that something different? All right, so which do you think is most appropriate?
Track 1 and 2 in my opinion.
All right, CAT's 1 and 2 theft course. And does that encompass the MRT?
No, Judge.
All right, the MRT. With regards to Houston, are you asking that it be transferred to Houston?
Yes, ma'am.
And I'm so sorry, is that Travis or Harris?
It's Harris.
Okay. Transfer to Harris County. Field visits, Miss Abram, is if they do them 1 time per month for 6 months. And there's to be no contact with the complainants.
Judge, one of the complainants is Mr. Lunsford's father. He did not ask for restitution, and he still enjoys a good relationship with his father. So I would ask that not be enforced.
We agree with that.
All right, there's to be no contact with the complainants. The only exception is the defendant's father. Probation, is there anything else?
No employment.
Handling any type of financial transactions.
Nothing else, Judge.
Is there anything else you need from the court to be successful?
No, Your Honor.
Did you assess a fine? I believe our plea bargain included a fine.
All right, there's a $10,000 fine. The court will probate 5,000 of that. No one usually know where the fine goes. It ends up disappearing and we can never track it. That's not me, that's the government who cannot track it. All right, there's a $10,000 fine. 5,000 of that would be probated. If you successfully complete everything, you only have to pay the $5,000. If you do not, you're looking at the full $10,000. Do you understand?
Yes, Your Honor.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because it's plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So here's the thing, since you accepted the guilty, even if you would not have accepted the guilty, this is a crime of moral turpitude. Anything that requires a license, you need to let them know that you have this. Do you understand?
Yes, Your Honor.
All right. Is there anything else from either side?
Just one minor thing, when we did the plea, there was a page in the SIPs that had a secured area with a postage stamp. And I have the updated clean version of it.
All right, thank you. And you're offering this?
Yeah, I'll hold up and see it's the copy without the instruction.
We talked about it before, Your Honor.
All right, then the court will accept an amendment to the stipulations. And it appears to be a document from the Texas Department of Insurance. And I'm sorry, one more thing. He has given up his license, correct?
It's been revoked, Your Honor.
All right, is there any request that he's not to obtain any insurance license?
It's not part of our plea bargain, but obviously the felony conviction is something that
we don't have an objection at the court entering that.
Yes, I'm gonna put that in because you never know what will happen. So, defendant is not allowed a license in, insurance, any type of insurance. All right, once you go over, the paperwork with probation will be excused, and this court communication is key when you're on probation. If there's an issue, let probation know about it. If you feel they're not addressing it, you can come back to the court.
So will I be contacted if she's in probation?
They'll talk to you about that.
Okay, thank you, ma'am.
All right, thank you.
We're
Thank
off the
you.
record, Your Honor.
Yes.
Mr. Locke tells me your social media followers send you the flowers. I just get death threats from mine.
No.
Good for you.
So here's the thing, they do not.
I was,
No, I buy my own flowers.
Okay.
This is my mom. My mom says that other than being at home, the most time you spend is at work, and you should try to make it as beautiful as possible. So she would always tell me all the time, she said, if you cannot spend $20, because that's what it costs, if you cannot spend $20 on yourself, then what are you working for?
good for you.
But so
Good for her.
that's me. That's me. This is for Bosses Day.
Mm.
So, and my staff is so awesome.
I just got death threats on Boss's Day too, but that's.
Oh, that's messed up. Oh, and I forgot. So, and also my students will send me flowers. But it does, for the record, it doesn't improve their grades. Their grade is their grade.
Thank you, Judge.
Thank you. You're welcome.
Payne and Daryl, and with Amos Abrams' assistance, we have suggested and spoken to Julian Gonzalez, who's with supervision, who's gonna work on the Tacoma screening within the next 2 weeks to get him over to the MIC unit. I also received a point of contact, John Lapointe, who's over the Fact and Act team. And I will be calling and contacting him directly to get that referral process expedited for him to resume with services with Fact and Act team. And skip going back to the intake process downtown, because that seems to be the level of frustration with waiting there for hours. And then at that, he's not getting seen. So what I've told both Mr. Paynes is that I will work alongside with them, along with Christine, to make sure all of that gets taken care of. We've exchanged numbers, and I think we're pretty hopeful that this will be set in place for him.
All right, and see, and here's the thing. She is not even a part of this equation legally, but she's coming down to help. She knows Miss McDonald well, so they can confer with each other to try to get your brother the help he needs. That's what everybody's trying to do. And I always say, many times frustrations are misplaced. My funding, well, people always think, oh, Judge, what's your budget? I don't have a budget. You know, it's me picking up the phone, calling people to see if people can get in the placements they need, because I want him to be successful. McDonald wants him to be successful. The prosecutors want him to be successful. So when you feel frustration, I guarantee you, the reason why things are not moving the way you think they should be, it's a funding issue. So write to your legislature and tell them there needs to be more funding for mental health, because the line is long. So before taking your frustrations out on anyone else. Yeah. All right. All right. So what we'll do is we'll call this back. Is November 20th. Is that enough time for everybody to see where we are?
I think, yes, that's enough time, Judge.
All right. So we're going to come back, Mr. Payne, on November 20th and see where we are. And have you been able to get your exercise in and walk around?
Yeah, yeah.
Okay, and then returning back where you're supposed to be?
Yes, ma'am.
All right, anything else you need help with?
Ma'am, I'm fine.
Okay,
I'm on.
all right, just continue the good things. I've been having good reports, okay?
Yes, ma'am.
All right, and we're gonna try to make sure we work this other component out.
Yes, ma'am.
All right, thank you.
Thank you.
Thank you, Mr. Payne, for looking out for your brother. All right. Yes, thank you guys so much. Oh, he needs a reset form. All right, and Mr. Sanchez, what page is he on? Lopez?
Page 3, third one down.
All right, Mr. Lopez? Come forward. Hello. All right. Sorry about the way that you can tell it's been, Mondays are always a little hectic and busy.
I see that.
So what we're gonna do, I'm being told that your attorney is in jury trial. So we're gonna recall you back. Norma, let's just recall him back for the 20th and see where his attorney is and the trial. So they're gonna give you a reset form. Once you receive that, you are excused.
Yes, sir.
All right, thank you for dressing appropriately for court.
Thank you.
All right, the parties on Keating. Good morning, how's it going?
It's going. I went to Formula One yesterday.
Oh, how was that?
There wasn't a single pass the entire race. It was the most boring sporting event I've ever attended.
You know, I always wonder, because I've never been, but you know, from what I've seen on television, it seems like it's very loud.
It was. It absolutely was. Hearing protection is necessary.
I saw one where, I can't remember which race it was, but one of the tires came off and flew into the stands. People don't realize how
Oh, yeah.
that's dangerous.
Absolutely.
All right.
We have an agreement with the state. We're gonna modify the terms.
And what is the terms being modified to?
We're gonna add MRT.
Mhm.
And we're gonna add specifically that before he travels, he must notify probation via email 24 hours in advance. So there's no question about the communication, because the court had granted him permission. The allegations are that he didn't have permission. So we just wanted to clear up any confusion with probation by adding that requirement that he notify them 24 in advance.
Ms. Abrams, on Mr. Keaton, what are you all requesting?
Your Honor, if I may, I discussed with, Officer Keeney and with Ms. Abrams, that we wanted to add some language to his amended conditions so that because he was allowed to travel within the US and internationally for work, we just wanted to add some language that he be required to notify his probation officer ahead of time so that, like Mr. Mailer said, there's no confusion as to where he is or why. And I'm not sure if Ms. Abrams said anything more specific.
That is correct. On the court summary, it says to amend for MRT and a GPS device for 6 months. I don't think the GPS is really necessary, Judge.
So what about the MRT?
We've agreed to it, Your Honor.
Okay.
That's part of
And then the notification for work, what time frame are you all asking for? And is this notification for work that's out of state, out of county?
I would say out of state and out of the country unless probation needs it to be out of it.
That's correct, Judge.
So just out of state?
And out of county and out of
Country.
country.
All right, so alternate main conditions, you to notify probation of employment that's out of state and out of country
Ahead of travel.
within, you want it 24 hours before?
If we can get
48.
48 to 72, that would be great.
I don't think we have any objection.
Right, 48 or 72 hours.
48 would be great, Your Honor.
All right, 48 hours before leaving. And then what is the issue with the field visits?
There was confusion there because he has multiple residences. He's allowed to live at either residence per the court. And he's actually, I've shown the state emails, he's attempted to coordinate with probation.
So where is he gonna stay? He needs to pick a residence.
Yeah.
His Sun Oak residence is fine, Your Honor.
All right, then you need to be available for field visits. And those field visits will start now for once a month for 6 months.
Okay.
All right, is there anything else?
I think so, Your Honor.
So you,
Oh, sorry.
so you, did you want the MRT, Judge? Are you
Yes.
referring it?
And MRT. All right.
I would remind the court that they ordered him to GPS as a condition of bond on
Mhm.
this. So yeah, just as soon as he can get that.
So is he currently
He
on
has
GPS?
GPS on, need the removal.
What's the issue I'm saying?
GPS need the removal order.
Okay, that's fine.
And let me see. Just one moment, let me go into the system. All right, and Miss Abrams, it'll be removal of GPS?
Okay, that was the, condition block, right?
Yes. All right, is there anything else?
Nothing further, Your Honor.
All right, thank you.
Thank you. Have a nice day.
Welcome. You too. All right, who's next?
Next, on page 5, 6, and 7, Officer Carvajal.
Carvajal. Carvajal? Hello, so what is happening with Mr. Carvajal?
We're co-defendants with Mr. Castañon, who was here earlier, Judge, so we have the same large amount of discovery. We want to provide the terabyte drive as he's going to do. So we're asking for the same 30 days that you were gracious enough to give the co-defendant.
Okay. I hate that time. All right, so it'll be November 20th. I think that's the date that the other
Did,
person.
I leave on the 19th. Could I do either a week after or a couple of days before that date?
Let me see. Well, which do you prefer, the week?
I'd prefer the week after if possible,
All
or
right.
sometime after that date.
Then that would have to be, Norma, are we able to put this on December 1st? Then
Thank
that will be December 1st.
Thank you, Judge.
All right, thank you.
All right, I'll see you before then. All right, bud.
All right. All right, anyone else?
Yeah, page 3, second one, Gabriel Carvajal.
Gabriel Salazar. Judge. Good morning. Yes,
Judge, we're set for a motion to suppress.
Yes.
Today, defense is ready.
all right, State, are you ready?
Judge, so this is a case that Lauren was handling. I understand the state, she's not present today. It's not aware that for a motion to suppress on today, so the witness, need to proceed on the witness not present.
All right, when will you be able to have the witness?
Judge, my understanding is that when we were here on court, I think it was September 18th, the court said that we were set for motion or plea today. And so
No,
Noted.
today is plea deadline date or motion to suppress.
motion to suppress. And so I followed up with that just to make sure. So if
Yeah.
we don't plead, it'll be a motion to suppress. Court said yes.
Mhm.
So I've been in email contact with Lauren regarding the reason for my motion and
Mhm.
our argument. And so we've kind of gone back and forth.
Well, have you had a chance to confer with Ms. Galloway?
Well, she brought in a pretrial for the officer and the officer did not show. And so she let me know that via email back in September. I said, well, how are we going to proceed with the hearing? And I didn't hear back from her. So I understand she's out today, but my understanding is that we were set for a motion to suppress.
All right, so this is what the court is going to do. Court is going to recall this for tomorrow for your motion to suppress. And we're going on the motion to suppress tomorrow. And if the state doesn't have witnesses here, we're proceeding on the motion to suppress,
And not today, correct?
not today. So tomorrow, Norma, recall this for tomorrow at 10:30.
Yes.
So at 10:30 tomorrow, I'm going to call it for the motion to suppress. All right, thank you. All right, who's next?
Next, I have on page 1, 4, and 5, Alexis Gabriel.
Alexis Gabriel. Oh, and then she has,
Mr. Sanchez.
all right, this, just let me do this and then I'll take that up. All right, where are we on this case, counsel?
Judge, I had given the state a hard drive to put on one of the cases. After I reviewed the hard drive, it turned out to be a case I already had.
Oh.
So I've given them another hard drive today. I'd like to come back in 2 weeks.
All right, Ms. Ferguson, if you could set this for 2 weeks for discovery, please. All right, we'll come back on November 3rd.
Thank you, Judge. I appreciate that. And I also have Mr. Martinez.
Okay, just give me 1 second.
So we'll be back November. Judge, can she sit down now?
Oh, yes.
Yeah, she can go back.
I just have to put everything in Odyssey.
No worries, Your Honor.
Martinez?
Sorry that you had this.
All right, what page is Martinez on?
Page one, fourth one down.
All right, yes, counsel, where are we on this case?
Judge Megan is just about got the photo lineup set up. And I think that if we come back in 2 weeks, we'll have accomplished that.
All right, so then I'll put this for November 3rd.
Thank you, Your Honor. I think that'll work out perfectly.
All right, thank you.
Just may we be excused.
Yes,
Thank you, Your Honor.
you're welcome.